Afternoon. My name is Nagai Pendel. I'm the Dean of the School of Law. And so before we begin today's program, I would like to acknowledge that UBC's campuses at Point Grey and Robson Square are situated on the ancestral and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh First Nations. I would like to acknowledge that those of you on Zoom who may be joining us today from many places, near and afar, I acknowledge traditional owners and caretakers of those lands. Before I get to the Zoom housekeeping items, let me get to some room housekeeping items, which is we've got this lovely lunch, and we found that now is the perfect opportunity to unfurl and unrustle and do all of that noise so that we can leave it noise-free when we have the true important speaking points. And then turning to Zoom, a couple of housekeeping items. If you are attending virtually and experience any technical difficulties, please reach out via Zoom chat for assistance. Please be sure to direct your question to the host. We have additional colleagues on the line whose webcams are turned off, but they're assisting on the back end. We'll have a short Q&A following the lecture. If you're attending virtually and have any questions for the speaker, please use the Q&A box to submit them. In-person attendees, please just, of course, raise your hand. This event is co-hosted by the Allard School of Law and the Canadian Friends of the Hebrew University of Jerusalem. So today's speaker, Dr. Shiran Reichenberg, joins us as a 2024-25 participant from the Morley Kaufman QC Memorial Allard School of Law UBC and Hebrew University Law Faculty Professor Exchange Program. The law school is delighted to participate in this important exchange, which fosters transnational scholarly relationships and knowledge exchange, while providing a chance for faculty members to embed themselves in both the faculty and country that they visit. This faculty exchange program was originally established in 2010, thanks to the generosity of a committed group of donors. From 2013 to the spring of 2019, the program was named in honor of alumnus Mitchell Groper, KC, to recognize Mitch's ongoing commitment and leadership within the Jewish and legal communities. In the spring of 2020, thanks to a very generous gift from the Kaufman Family Foundation, the program was renamed to honor and celebrate the contributions and achievements of the late Morley Kaufman QC, who was so instrumental in the success of this exchange. I'd like to acknowledge and thank all the other program donors and champions, the Canadian Friends of the Hebrew University of Jerusalem, for their involvement in ensuring the establishment and continuation of this exchange over time. Thank you very much. And now it is my pleasure to introduce today's speaker. Dr. Reichenberg is the Executive Director of the Clinical Legal Education Center at the Faculty of Law, Hebrew University, Jerusalem. She also directs the Youth at Risk Clinic. Her research focuses on children's rights, youth well-being, access to justice for marginalized youth, the welfare system, and the intersection of gender and vulnerability among girls at risk. Her work bridges legal frameworks and human rights principles, emphasizing the application of children's rights as fundamental human rights. Please join me in welcoming Dr. Shiran Reichenberg.
Thank you very much for your kind introduction and kind words. And I want to thank Allard School of Law and the Faculty of Law of the Hebrew University and the Canadian Friends of the Hebrew University for allowing me to be here and do this amazing journey to Vancouver and teach and talk about children's rights. And also, I want to say that feel free to eat, make noise, it's fine. In our legal clinics, we always eat in class. It's part of breaking tension, and also everyone's more comfort when they are not hungry. So don't worry about it, and feel free to enjoy your lunches. And before I start my talk, a bit hot, I want to speak about the fact that I come from Israel, and which I'm sure all of you know and aware of the reality, the horrible reality that we are facing in the past year and a half with the war. So first, I wanted to show you pictures that were drawn by Israeli and Palestinian artists for an exhibition organized by a children's rights organization in Israel. And this was called For Children in Wartime. And I want to quote some of the things they said about this exhibition, which is, some 70 artists accepted our call to participate in a street art exhibition, raising a cry to end the war and prevent the further suffering of children living in Israel, Gaza, and the West Bank. The artists come from diverse backgrounds, both Jewish and Arab communities. And I want to join their wish and wish that the hostages will return and that the war would end. So, moving to my talk today, I want to bring you the voices and the legal aspects of girls at risk in a locked residential care, the right to participation and the legal representation, and also other aspects of the risk and the effects they have and social structures relevant to their place in the legal framework. The data is based on a research I conducted in a locked residential care for young girls. No, I'll go there to that first. So my talk will be about care proceedings, about current legal situation in Israel, other relevant theories, the intersectional theory, and other issues, my main findings from the research, and to give you some perspective of the voices and what is my take-home message for you. But I want to tell you first how it all started. So when I was a second-year law student, I walked into this place called Masila. It's a word Hebrew. And it's a locked residential care for young girls. It's for young Jewish girls. There is another one for Arab girls, but I came to this one. I don't speak Arabic. And I got to Masila in my second year as a law school in a legal clinic called Street Law, which is now part of my legal clinic of youth at risk. And in street law, we law students go to places where the children are at and teach them laws and their responsibilities and also their obligations and their rights in the legal system. And in the end of the year, we do a mock trial, which they write all the cases and they act all the participants in the trial. They are the witnesses, they are the lawyers, and it's a very empowering program. But for me, it was a life-changing experience, and I'll tell you why. All the girls in Masila, in this place, are under a youth court order, either because they committed a juvenile delinquents, or most of them are under a care order. This place is a locked residential care, which means it's locked. It's like a prison. You can't enter the next door if the door behind you is not closed. And you have to remember, those are all girls that something happened to them. Most of them didn't do anything wrong, just some sort of trauma occurred during the life processes, and it caused them a series of events that at the end, they were placed there, and it's supposed to rehabilitate them and give them tools to go back to society afterwards. And all of them were suffering abuse or neglect, even if they came under criminal proceedings. So basically, they did nothing wrong. But there was another thing in this place for me. It was the first time that I met young girls who weren't so far from me with my age. I was then maybe 22. They were 16, 17. But their life experiences were so much different than what I known until this moment. Some of them needed to be given the most basic skills of life. They didn't know how to shower, they didn't know to brush their teeth. Some of them changed night and day and night, because in the streets they were usually sleeping during the day and out on night. And some of them were still with the specifier suitor, even though they were so big girls. And seeing them, understanding their life is a completely different thing than what I have known and met so far, made me wanting to devote my professional career to put their stories and reality out there. So this is what I will talk about today. So I work at the Youth at Risk Legal Clinic, represented over 70 young girls, I think, and boys, but most of them were girls, and teaching and talking to my students about the gap between law in books and law in action. And all of you who did legal clinics here probably know that this is the core basic idea of what we do. And this research is an empirical research that combines also social work, academic discourse. So when I started my research, I had those questions in mind. First, what is the normative framework of the right to participation in current supervision proceedings? So my students sitting here have heard so much in the past 2 weeks about the right to participation, but I will talk about it a little bit later on. How do adolescent girls experience their involvement in current supervision proceedings, particularly relating to the right to participate in the proceedings? And what is the potential for implementation of this right under the existing legal framework in Israel? So first, I want to give you some numbers about how many youth we are talking about. So in care proceedings, all in all, in 1 year, almost 10,000. Also in criminal proceedings, 10,000 proceedings in year in all of Israel. When you apply for a care order, you can notice here that almost 100% of the application are accepted by the court, by the youth court mainly. And during those proceedings, both in criminal and in care proceedings, almost 12,000 out of placements resolutions. Why I chose girls is first because I experienced that they were silenced no matter where they were at or where they came from. Their homes, their societies, their community, and also in the court proceedings where I've been with them. So I've been trying to put out their voices. But also, I always felt that as a lawyer, the legal proceedings were not exactly what they should be for them to be able to speak out and put their voice out there. And also the legal implication and the balance between protection and participation regarding putting girls in locked residential care was something that I wanted to explore and see how it can be balanced during legal proceedings. And one thing that was very important for me to put out here, that when girls are in distress and experience trauma, they tend, first of all, to harm themselves more than others, unlike boys in similar situations. So the distress is expressed through sexual behavior, prostitution, running away, anxiety, sometimes use of substance. And they are more likely to develop post-trauma and depression than boys as a result of their severe distress they have experienced. Also, adolescent girls at risk out of home residential care experience a unique vulnerability that can impact their mental and physical health, as well as their social and emotional well-being. And studies also indicate that girls placed in out-of-home care, compared to those who are staying at home, are more likely to experience academic decline, violence, homelessness, early parenthood, economic hardship, criminal involvement, and others like physical and mental health difficulties. And we need to remember what I've constantly said to my students is that when we are in a situation that we want to take girls out of their home, we need to give them a solution that is better for them than what would have happened if they have stayed at home. And if this is the situation, then something in the way is not working unless you're right. So this is another thing that I wanted to understand more deeply. So the background, the legal background for care proceeding in Israel is the Youth Law of Care and Supervision. It was legislated in 1960 and it amends the relationship between the family and the law. And you can only activate the law when the child or the parent are not consenting to the care plan that was suggested by the social services. Meaning, if a child is a child in need for some reason, and there is a social services committee, and they decide that he should be placed in out-of-home care, and he thinks so, and the parents think so as well, there is no need for a court order. They don't have to go to any youth court at all. He can be placed in this facility, and there is no legal supervision of the decision. Only when either the child or the parents or both are not agreeing with the care plan of the social services, only then we apply the law. And then when we apply the law, it can only be applied by a special social worker that we call social worker for the youth law, who needs to hand the court statement saying why this child is a child in need. This is the phrase that we use. And when the court decides that the child is a child in need, it's called parens patria. The state, by the social services, enters in the parent's shoes and is charged of all the issues that are relevant to the treatment of the child, beside decisions that are relating to the body and health. Meaning, even if a child is being removed because, for example, one of the parents abused him, and he needs to receive medicine or a care treatment, like a health and hospital treatment, we still need the approval of the parents. It doesn't disconnect the guardianship of the parents. It just puts the kid under the social services therapy. And another thing that is important to know, that the law applies on children between birth until the age of 18, which means that everything I said so far is relevant to all the spectrum on these ages, and you can understand that different children in different ages need different kinds of treatments, but still this law applies on all of them. And this law can be activated mostly in youth court, that we have a special youth judge, but also in family court, but it's almost in rare decisions where there is a dispute between the parents or divorce, and it's so hard that they need to apply the youth law, but mostly it will be in the youth court. And thus we have the right to participation in our youth law. So basically, not really. This law was legislated in 1960, meaning it has the 1960 concept in it. It's very paternalistic. It doesn't apply most of any of the UN Convention on the Rights of the Child principle, which I will talk about in a minute. And how we define by this law what is a child in need is very wide, and it's under interpretation. So it can have the interpretation of the specific social worker who's working on the case, while other might think otherwise. And it's open to also personal bias. When regarding for the child to express his or her views, there's only one article that allows the court, when hearing a case of a minor, may at any time appoint a guardian ad litem for a minor if it finds that it's necessary for the best interest of the child. Now, it's an article that was legislated in the 90s, 30 years after this law. It was amended and added this possibility of basically legal representation, but it has a lot of obstacles in it. First, it's only when there's a case in court, okay? So as I said before, not all the cases come to court. Second, it's up to the judgment of the judge, because he may at any time during the proceeding or may not. Like a judge can decide not to appoint a guardian ad litem. The next issue is what a guardian ad litem is. Now, I don't know if any of you have any concepts or ideas, but it doesn't, I mean, there's countries where a guardian ad litem is not a lawyer. In Israel, it's always a lawyer, but because it's called a guardian ad litem, I read when the parliament legislated this specific article, after they passed it, one of the presents in the room, she asked, okay, so what is a guardian ad litem is? And the chairman of the committee said, we don't have time now, we'll discuss it later. And so far, they hadn't had a time yet. So it's been like, I don't know, 20 years. And so it's come to become a lawyer. But what are these lawyer obligations? And does he under the ethical law of the bar, of the lawyers, or not? Because if I am a lawyer and I'm in charge to tell the court what is the best interest of the child, what do I do in cases when the best interest of the child is not what the child wants? If he's my client, should I speak up what he wants, no matter what he's saying, or should I follow the law? So it puts on the lawyer a lot of pressure and also a misunderstanding of what his job actually is in those proceedings. So the paternalism of the law, together with the lack of listening and understanding the girls, particularly regarding the complexity of the situation, and it creates a lot of first possible harm for the girls and also a lot of issues relating to trust, because if I'm standing there as her lawyer, not saying what she wants, but what I think is best for her, she has no trust in me. I lost her that same second. So as a result of this situation and the fact that the girls are not considered active participation in their own legal proceedings, something that I forgot to mention before is that actually the proceedings are filed by this special social worker for the law against the parents about the child. But the proceedings are actually between the state and the parents, and the child is not part of the proceedings. So putting all of that together, and the fact that there is not always a legal representation, and it leads to a situation where girls may be placed in a locked residential care without ever having appeared in court or meeting their judge. So another legal theory, important one that we have is, of course, the Convention on the Rights of the Child from 1981, which Israel signed and ratified in 1991. And the main principles of the convention are, first, the best interest of the child, the right to equality, the right to development, the right to participation, and all of this is under the evolving capacity of the child. Now, I feel I spoke so much about the convention in the past 2 years, but not to all of you. So if you have questions regarding the relationship between the law and the convention, I would be more than happy to answer. But I'll just say that the convention is not part of our legal system unless we legislate it in our laws. So it's an interpretative rule that supposed to guide all of our action, but it's not part of our legal system unless we put it inside a national law. And this Article 12, the right to express view, the right to participation, which guarantees that the state's party will assure the child who is capable of forming his or her views the right to express views freely in all matters affecting the child and the views given due weight. The Committee of the Rights of the Child from the UN Committee on the Rights of the Child interpreted this specific article as the right to legal representation, because one of the things they said is that for a child to be able to express his view in a courtroom, he needs a legal representation. And as you remember, in care cases, we have just the guardian ad litem. So the right to participation is a key component in any children's rights discourse and should guide any theory on children's rights. And then after looking at the legal situation, both the youth law and the Convention on the Rights of the Child, I looked at the girls themselves. And there is a theory called intersectionality theory, which is talking specifically about people who are in intersections. And when you put it on girls, especially girls in distress or at risk, and the intersection of all their identity factors, their gender, their puberty, their ethnicity, their culture, maybe sometimes poverty, all of those situations is putting them in a unique, marginalized situation. And those are the girls who are entering most maybe all of the girls who are entering a locked residential care, they're all under this intersectionality state that puts them in more danger than others. The methodology for the research, sorry, I also just finished teaching a class of 3 hours, so I'll drink. So the methodology I used in the research was in-depth interviews of 12 adolescent girls placed in Mesila. 11 were Jewish, 1 is Bedouin. A qualitative critical feminist interview analysis and ethnography with reflection based on my professional experience. All the girls were under care order. Some had also parallel criminal proceedings. And the analysis was based on the interaction of the girls with the relevant stakeholders, family and or parents and or social worker, lawyers, judges, and the care staff in the residential care. So now I'll go to the finding. My first, and I think one of the most important finding in the research that came out from what the girls were saying is that the right to participation is a life skill. They don't know how to participate in their proceedings in a way that we can understand what they are saying. They are acting out in a different way, and they also don't always know the language, what's need to be said and done in order for them to be part of their proceedings. And the implementation of the right to participation is a direct result of the right to be heard, as it specifically said in the convention. So in order for the girls to exercise their right to be heard, the various actors involved in the legal process, those who interact with them throughout their proceedings, must provide them with the opportunity to express their voice. This means actively listening to what they have to say. So these are the words. Every time I was given another reason why I was in hell, why things wouldn't get better for me, why there was no way back, and how I had to survive, take responsibility for myself and be alone. And that if it's a court order, then it's a court order. No one would come and take my side. Even if they heard me, they would see me as just a little girl, ignore me and push me to the side. Like, who are you anyway? What do you want? Okay, you've had a tough life. Now sit here quietly. That's how I felt, like a dog being tossed from place to place, from one place to another. The other finding I had was that locked residential care is another intersectionality cross for those young girls. 2 or 3, I think, even of the girls that I represented, not the one that I interviewed, when they were out of the residential care and wanted to enter a learning program, not even school, it's like a special program for dropout kids. The social services in their cities say that they don't want them to enter because they're like Mesila girls. So it's like they had this sign on their forehead saying they're not good enough for anything. So beside all of those culture, ethnicity, poverty, and gender they were already in, being in legal proceedings and in locked residential care was another intersectionality cross for them and their reality. And they said, what do you want from me? What have I done wrong? Why I don't deserve a normal place to be in? I didn't feel safe. I felt so alone, you know? So most of the time I found myself running away, running to the unknown, just like that. I prefer to sleep on the street, on the bench, to stink than to be in this institute. And running away from institution is one of the most common things that is happening with youth at risk. And when they come back, they are usually being punished instead of being asked what happened to you that made you run away. And this is something that she was talking about here. All this time, you took my life and my choice. You didn't give me any right. So when you choose for me, at least do it with humanity, not cruelty. And there is no one. No one hears, knows, sees, or cares. So everything that is happening there stays there. Another important finding that the lawyer should represent the girl's voice and earn their trust, and not what he thinks is best for her. And again, it's something that we just talked about. I was never a girl in a locked residential care. I would never understand for the depth of her life story. But what I can do is listen to her and put her words out there for the judge to hear as well. But the girls stated that the lawyers don't explain the legal process to them, don't communicate what the girls have asked them to, and sometimes even act against them. They feel that the lawyers don't understand them and don't represent their wishes before the court. I thought the lawyer should be in my favor, but what she does, she doesn't. She hears me, but her opinions are what the welfare decides. Is that what she says in court? Yes. She doesn't come and say, listen, but the girl's like that, and like what? I'm really telling her. I asked for something, and the welfare was against, so she was also with them. And I also think that we need to respect the experience those girls have and treat them like experts from experience. And when I ask them at the end of the interviews what they think needs to be different, they said more conversation, to listen more and really try to understand, but mainly listen to the girls because they say and write things about the girls that they only hear from someone but are not connected to reality. Like if some girl was raped or got pregnant from a guy, maybe her first guy even, she's immediately in need for treatment for her behavior with men. She drank one time in a vacation, she's an alcoholic, even if she is not addicted. Things like that. They need to start by not making conclusion on the girls, but to understand from them. Because when you make conclusion on them, you make her what you think she is. And from that, the deterioration can begin. And it is crucial to pay attention to what the girls think and do understand the consequences of not listening to them. Within care and supervision proceedings, lawyers and judges should work to build the girls' trust in the system and ensure that they feel cared for and supported. And also, we need to remember, most importantly, that in the system, no one knows those girls that well. It's not like when we are fighting for our children's rights in front of the teacher and we feel like we know what's best for them and we can argue their case. They are in a facility under supervision of some stranger, not family related. So this is very important to give them all the information and put their voices out there. The role of the youth social worker and the workers at the locked-in residential care is to strengthen this trust and equip the girls with the necessary tools to help them live as normative life as possible. However, the girls describe that the lack of listening from these various authorities undermine their faith in the legal and social care system's ability to truly help them. Another thing that came to me from the interviews was that basically, even though the youth law and care system is always with a treatment person in the room, we should adjust the therapeutic jurisprudence principle. Therapeutic jurisprudence is a legal theory that was developed by Wexler and Winnick, which aims to raise awareness among legal actors like judges and lawyers and policymakers about the therapeutic dimensions of a law as an additional principle alongside other traditional legal considerations. It emphasized the study of a law's role as a therapeutic agent and is based on assumption that law is a social force that can do both, either encourage positive, constructive, and rehabilitative behaviors or generate negative, anti-therapeutic consequences. Therefore, therapeutic jurisprudence advocates for examining the legal system through this lens, promoting legal practices that led to positive, therapeutic, humane, and restorative outcomes. And to not cause the girls feels like that. I felt it was all just a lie and that she, the judge, it's just her work and she has a different perspective because they bring her my reports and she reads them and say, okay, if this is the situation, I will take Masila's advice. I won't believe the girl and maybe this is a good way to go. But she doesn't really know me. She doesn't know all my past. Even my personal files doesn't have everything. And I think she needs to look deeper and not judge by reports and file. Someone should believe us. And I don't have time to get into depth about social reports, but there are also another something that is one-dimensional for the girls. They stand in court, someone's reading about them, telling all the horrible things that happened to them from a paper. And it's also something that they talked about a lot. This is regarding their family. They said it's 3 different girls. She said one, A witch mother is a witch mother. That's how I saw her. I never knew a mother who hugs, a loving mother, a supportive mother, a mother who regrets, or a mother who would say, stop doing that. I was 8 years old when I ran away from home for the first time. I didn't get along well with my mom. Now my mom is in prison for what she did to my sister. My parents divorced when I was 8, and my dad met someone and I didn't get along with her. We were always fighting and it was chaos in the house, and I was disconnected from my mom for a long time. And this is what they said about the social services. Like, they seem like they're listening, social worker, but they have their own opinion and they never change them. It's like they just leave me stuck in a place and walk away. Like they don't care what I've been through here. They don't care about anything as long as I'm not at home, as long as the noise isn't their problem. And if I could, I would say to the judge to really listen to the girl, not how you look at them from her reports, because the reports are something that's written about you. She was this way and that way, but you don't really know what our souls are and don't know what we really think, you know? So I asked her if there was something you could say to the judges, lawyers, and the people who treat you, what would you say? That they will listen to us, the girls, more instead of looking at the reports. Reports can be full of lies, but instead everything I said turned to something bad. So this research is an example how the work in the field of the legal clinics can impact the academia and go back to the field, because after I conducted this research, they established a youth representation unit in the legal aid, and they got some of the recommendation to the work of the guardian ad litem. It's still a guardian ad litem. They hadn't challenged like the whole concept. But I think it's important to use what we know and learn and to put it in real practical life, because this is what we really believe is the true clinical legal education can provide. And my take-home message for you is the need to legislate and update youth law for us, actually, ensure an effective participation in legal proceedings for youth at risk. The girls are a source of knowledge and we need to respect that, and listening to what the girls truly want and need. So thank you for listening.